All right. Are we on now, Ms. Jones?
Yes.
Should have lowered the lights?
Well, I lowered one. If we'll be in complete darkness if we close
Okay.
the other one.
Okay.
Which could be exciting.
We'll just ask people on the platform to say their name and spell it.
Okay. Good morning, everybody. Good to see everybody here and all our board members, and just starting the meeting. It is 9:09 a.m. on Friday, November 17th. And we have our meeting. So to start off our meeting, Ms. Jones, would you please do a roll call to see which members are here today?
Yes. Good morning. Member Bitzer, are you present?
Present.
Member Ely?
Present.
Member Honker?
Present.
Member Garcia?
Here.
Vice Chair Trujillo? Okay, Chair Sweeney?
Here.
Vice Chair is. There she is.
She's married.
Vice Chair, can you hear us, and can you unmute and give us a sign of your presence?
Yes, can you hear me now?
I can hear you. Thank you.
Okay, looks like there's a disconnect between calling in and using the platform on the computer. So I will make sure to try to keep that straight.
Thank you.
Thank you, Vice Chair Trujillo. So we have our members all here today. That was agenda item number 1. Agenda item number 2 is approval of the November 17th, 2023 agenda. And just looking around and looking at Vice Chair Trujillo, Ms. Bowen, no other changes. Ms. Jones?
Yep.
Nope. All right. So
I'll move we approve the agenda.
thank you, Member Hunker.
Second.
Thank you, Member Bitzer. Could we have just a quick roll call vote on the Member Hunker's motion?
To approve the agenda. Member Bitzer, how do you vote?
Yes.
And Member Ely?
Yes.
Member Honker?
Yes.
Member Garcia?
Yes.
Vice Chair Trujillo?
Yes,
Thank you. It's Chair Sweeney.
Yes.
Motion passes.
Thank you. We'll move on to the next agenda, item number 3, approval of August 18th, 2023 regular meeting minutes, and I believe those were sent out. Fellow board members, do you have any questions, comments regarding those meeting minutes? Any changes? No, and I don't see Vice Chair, and may I have a motion?
I will move we approve the meeting minutes from the August 18, 2023 meeting.
Thank you, Member Hunker.
Second.
Thank you, Member Bitzer, for your second. And Ms. Jones, would you please do a roll call vote on Member Hunker's motion to approve the meeting minutes?
Yes, ma'am. Member Bitzer, your vote, please.
Yes.
And Member Ely?
Yes.
Member Honker?
Yes.
Member Garcia?
Yes.
Vice Chair Trujillo?
yes,
And Chair Sweeney.
Yes.
Motion passes.
Thank you, Ms. Jones. And we're off to agenda item number 4, which is public comment. And again, just noting general comments not pertaining to meeting agenda items. Do we have anybody on that has notified you of?
No one has notified me ahead of the meeting. I see that Mr. Maxwell has his hand raised.
Okay, and Mr. Maxwell, yes, it looks like you're the only one. And I believe we do public comment 3 minutes. That's what we've been doing.
Right.
So, Mr. Maxwell, you have our attention for the next 3 minutes.
Thank you. My name is Nicholas Ray Maxwell. I am a citizen of Lee County. I'm here today to express a significant concern regarding the impartiality of the Environmental Improvement Board, particularly focusing on board member Ely. My apprehensions were heightened after learning about the professional background of her husband, who has been an advocate for Western Resource Advocates within the past 2 years. This issue brings into question the integrity of the board's decision-making process, especially in light of the hearing earlier this week. In that instance, I firmly believe that she should have been recused. The close proximity of her husband's advocacy role raises serious concerns about potential conflicts of interest, which should have been discussed and weren't. The appearance of the hearing, to be frank, seemed less than transparent and objective. To some, it might have even seemed as a sham. This perception is not just damaging to the credibility of the board, but also to the trust that the public places in environmental governance. To maintain the highest standards of integrity and impartiality, it's essential to reevaluate her involvement in last night's vote. More importantly, in situations like this hearing, where there's a clear overlap between board members and parties, recusal is not just advisable, but necessary. We rely on this board to make unbiased and fair decisions for the betterment of our community and environment. It's crucial that every member upholds these values in every aspect of their service. And thank you for your attention to this matter. I trust this board will take the necessary steps to address these concerns and restore public confidence in its decision-making process. Thank you.
Thank you, Mr. Maxwell, for your public comment. And is there, Ms. Jones, anybody else that would like to make public comment?
No, Chair, I see no other hands raised and I've received no chats of any sort.
Okay. Thank you so much. So with that, we will move on to agenda item number 5, which is public hearing EIB 23-52R in the matter of proposed amendments to 20.2.77 NMAC. And at this point, I think I turn it over to Member Ely as the hearing officer.
Thank you, Madam Chair. This hearing will please come to order. Today is Friday, November 17th, 2023. The time is now 9:16. My name is Sandra Ely, and I have been designated by the board to serve as hearing officer, and I will be advised by the board's counsel from the Office of the Attorney General, Emily Bowen. May we have a roll call of the board?
Yes, Member Bitzer, are you present?
Indeed.
And Member Chair Ely
Present.
and Member Honker,
Present.
Member Garcia,
Here.
Vice Chair Trujillo,
Here.
thank you. Member Sweeney,
Yes.
you have a quorum of the board, Chair.
Thank you. This is a hearing in EIB 23-52R to consider the proposed amendments to 20.2.77 NMAC, New Source Performance Standards, also known as NSPS, 20.2.78 NMAC, Emission Standard for Hazardous Air Pollutants, also known as NESHAPs, and 20.2.82 NMAC, the Maximum Achievable Control Technology for Source Categories of Hazardous Air Pollutants, also known as MAT. Although this hearing is being conducted in person, Rule 20.1.1.306 NMAC allows for participation via conference, telephone, or other similar device, given all participants are able to hear. If there are technical difficulties at any point during the hearing, please bring them to my attention and efforts will be made to remedy the situation. The petitioner in this matter is the New Mexico Environment Department Air Quality Bureau. Nicholas R. Maxwell filed a notice of appearance and is a party to this proceeding, but did not file a notice of intent to present technical testimony. Nicholas R. Maxwell will not offer any technical witnesses. There will be designated time for any member of the general public to present non-technical testimony. This hearing will be conducted in accordance with the Open Meetings Act, the State Rules Act, the Environmental Improvement Act, and the Air Quality Control Act, with the board's rulemaking procedures. This hearing is being reported by Cheryl Aregin from Albuquerque Reporting Service. Parties interested in obtaining a copy of the transcript may contact the court reporter directly at the conclusion of the hearing. Copies of the proposed amendments have been available on the department's website and at the department's office, as well as to interested parties upon request. The hearing will be conducted in a fair and impartial manner to assure that the relevant facts are fully elicited and to provide a reasonable opportunity for all persons to be heard without making the hearing unreasonably lengthy or burdening the record with unnecessary repetition. The rules of civil procedure and evidence shall not apply to this hearing. As hearing officer, I will make such orders as may be necessary to preserve decorum and to protect the orderly hearing process. To that end, I ask that all persons at this hearing please silence their cell phones. If appearing virtually, please be sure to mute yourself until you wish to speak to help minimize background noise. The hearing shall proceed as follows. Board staff will present pre-filed exhibits. Exhibits admitted into evidence are available for review by the public. All testimony will be taken under oath. As hearing officer, I will rule on any objections to evidence and will admit any relevant evidence unless I determine that the evidence is incompetent or unduly repetitious. Any person offering an exhibit shall provide an original to the board administrator and a copy to each board member and to its legal counsel, and shall also provide additional copies for persons attending the hearing. If visual aids are used, legible copies must be submitted for inclusion in the record. Please know that the board will not make copies of any exhibits used at this hearing. Any person who wishes to make a brief opening statement before presentation of his or her direct testimony may do so. Petitioner will present its direct testimony on the proposed amendments, and petitioner's witnesses will stand for cross-examination by Nicholas R. Maxwell, the board, and any other person in attendance. Nicholas R. Maxwell will then have an opportunity to present an opening statement. If any other persons, including members of the board, wish to present non-technical testimony about the proposed amendments, if any other persons, including members of the public, wish to present non-technical testimony about the proposed amendments, they will testify as called upon. If you are a member of the public, please email the board's administrator at pamela.jones@state.nm.us to notify us that you intend to present non-technical testimony and include any exhibits being offered. Because this hearing is being transcribed, please remember that only one person may speak at one time. Please direct your testimony and answers to questions to the board members. Any person who testifies is subject to cross-examination on the subject matter of his or her testimony and on matters affecting his or her credibility. The petitioner has the option of presenting its witnesses as a panel for purposes of cross-examination. Cross-examination by the board and hearing officer will be conducted at the conclusion of each presentation, followed by cross-examination by the other party, followed by cross-examination by the public. As a reminder, cross-examination is limited to matters contained in the direct testimony or to witnesses' credibility. Please remember to direct all testimony and answers to questions to the board itself, even if someone other than the board member has asked the witness a question. Any person attending the hearing is entitled to conduct whatever cross-examination is required for a full and true disclosure of matters at issue in the hearing. As hearing officer, I may limit cross-examination to avoid harassment, intimidation, needless expenditure of time, or undue repetition. At the petitioner's discretion, and if time permits, rebuttal testimony may be given at the conclusion of the public testimony in the same order as direct testimony. Any person who wishes to make a brief closing argument may do so at the conclusion of the hearing in the same order as direct testimony. We will now proceed. Does the board staff have any exhibits to introduce as evidence?
I received the notice of intent and exhibits 16 and 17.
Do I need to look at
Madam
them?
Hearing Officer, may I make a motion?
Yes, you may, Mr. Lino.
If there's no objection, the department, I'm Christy Hill, Assistant General Counsel, New Mexico Environment Department, I apologize. The department moves to enter, if there's no objection from the board, from the hearing officer, Mr. Maxwell, for NMED exhibits 1 through 17. Those are all the technical exhibits. 1 through 15 were entered in the statement of intent to present technical testimony. 16 and 17 were circulated, including to Mr. Maxwell earlier this week. Thank you.
I have no objection. Do I have to get it forward? I have no objection to the entry of those.
You should ask.
Mr. Maxwell, do you have an opinion on the entry of these exhibits?
No objection.
Those exhibits are entered. Exhibits 1 through 17 are admitted into the record. If there are no other preliminary matters, we will move to testimony by the petitioner. We will begin with technical testimony by the petitioner. Does the petitioner have a brief opening statement?
We do. Thank you. Good morning, Madam Chair, members of the board, our Madam Hearing Officer, Mr. Maxwell, and members of the public. The department is here today to provide technical testimony by the department's air quality bureau staff regarding proposed amendments to 20.2.777 NMAC, new source performance standards, 20.2.78 NMAC, emission standards for hazardous air pollutants, and 20.2.82 NMAC, maximum achievable control technology for source categories of hazardous pollutants. These proposed amendments are non-controversial, and the department has not received any comments from members of the public. The department is aware that Mr. Maxwell has entered an appearance in this case, but the department is not aware of the nature of Mr. Maxwell's concerns. But I do want to say, we're glad he's here. I'm not trying to make a glib comment. We just are not aware of what Mr. Maxwell's concerns are at this time. I did speak with Mr. Maxwell by telephone to try to get a sense of what his concerns were. But I think, as we all know, Mr. Maxwell has been busy with the Clean Cars hearing, so he was a little busy, so we didn't really have a full conversation. And I'll be curious to see what Mr. Maxwell has to say today. The purpose of the proposed amendments is to ensure that New Mexico's air quality law is current with federal standards, and to ensure that the department has the full ability to protect the health and well-being of the environment and the people and animals of New Mexico. The standards are already in place at the federal level. And as you are aware, New Mexico has a basic obligation to conform to federal air quality standards. And these amendments ensure that New Mexico will be up to date as soon as the proposed amendments go into effect. I will allow our technical witness, Mr. Paz, to describe the amendments in more detail. But the department is respectfully requesting that the board adopt these amendments. Today, I'm happy to have with me Joshua Hirsch, a clinical law student who is in his last semester at UNM Law. Mr. Hirsch has done a great job with the department this semester, and this is his final assignment. Mr. Hirsch is appearing under Rule 1-094.1B of the New Mexico Rules of Civil Procedure, which allow clinical law students to appear in court and administer proceedings under the license of a supervising attorney. As a preliminary matter, I'd like to, we already did that. Sorry, but I ended with asking to enter. We've already done it. So I'll turn it over to Mr. Hirsch and Mr. Potts. Thank you very much.
Just one second, Mr. Behill. I just wanted to note that the department you have identified Mr. Paz and Ms. Olson as a technical witness, and I think we want to swear them in at this point.
So I did hear you, I'm sorry.
I think we want to administer the oath at this point.
Yes, yes.
If you both would raise your right hands, do you and each of you solemnly swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth?
Yes.
I do. Will you both please say and spell your full names?
Armando Paz, ARMANDOPAZ.
And Kirby Olson, KIRBY OLSON.
Thank you. The petitioner may now present their direct testimony.
I didn't hear you, I'm sorry.
The petitioner may now present direct testimony on the proposed
Thank you
amendments.
so much.
Madam Chair, members of the board, thank you very much. It pleases the board to begin the direct testimony of Mr. Fox.
Please state that one.
Mr. Fox, please state your name for the record.
Armando Paz
Where are you currently employed,
with the Air Quality Bureau of the State of New Mexico Environment Department,
and what is your job title?
an advanced environmental analyst.
What are your job responsibilities as an environmental analyst?
I work with revising the state implementation plan for the southern part ozone attainment area and revise and implement the dust mitigation plan for Doñana and Luna counties. Also, I submit exceptional events demonstrations to the U.S. Environmental Protection Agency each year for exceedances of the national ambient air quality standards for particulate matter less than 10 micrometers in aero diameter or PM10 due to high wind blowing dust events. I represent the department as a committee member with the Joint Advisory Committee for Improvement of the Paso del Norte Air Basin, which is a tri-state binational air policy work group formed to strategize air pollution control programs with the stakeholders of the El Paso, Texas, Southern Doñana County, and the City of Juarez, State of Chihuahua, Mexico air quality management jurisdictions. In addition, I conduct rulemaking activities such as these incorporation by reference amendments that are proposed before you today.
How long have you worked in the control strategies section?
4.5 years. I began in April 2019.
Have you held any other positions with the environment department?
Yes, as an environmental scientist specialist for the previous 13 years. Prior to this position with the Environmental Health Bureau at the Las Cruces District 3 Field Office, implementing and enforcing the food safety and sanitation, public swimming pool, spa, and liquid waste programs.
Could you briefly describe your educational background?
My educational background involves holding a Bachelor of Science in Environmental and Occupational Health with a minor in Environmental Management from the New Mexico State University.
I direct your attention to NVD EIB Exhibit 1. Is this a copy of your latest resume?
Yes,
Did you submit pre-filed direct written testimony for this hearing?
yes, it is Exhibit NMED 3.
Do you have any corrections or additions to your written technical testimony that you would like to make at this time?
Yes, I would like to add Exhibits NMED 16 and 17 to my testimony regarding the public outreach components to meet the definition and provide to the public as described in subsection E of 14-4-2 NMSA 1978. NMED Exhibit 16 provides the screenshot of the Sunshine Portal posting on September 12, 2023, and the email sent to the Legislative Council Service. Exhibit NMED 17 provides the email to the Environmental Health Bureau Chief requesting for the public notice to be posted at NMED field office throughout the state.
Do you adopt your written testimony in its entirety?
Yes.
Mr. Paz, can you please provide a brief overview of your testimony?
Yes, my testimony begins with my education and work experience, then a summary of the proposed amendments to Title 20, Chapter 2 for Parts 77, 78, and 82 of the New Mexico Administrative Code, or NMAC, which references the sections of the Clean Air Act, Exhibit NMED 14, that pertain to the delegation of authority to the Department for the Resource Performance Standards, or NSPS, National Emission Standards for Hazardous Air Pollutants, or NESHAP, and Maximum Achievable Control Technology Standards for Source Categories of Hazardous Air Pollutants, or MACT. The Air Quality Control Act is referenced to provide the statutory authority of the Environmental Improvement Board, or BORD, to protect air quality by adopting the federal NSPS, NESHAP, and MACT standards. An update to the statutory reference for Part 78 and 82 was provided due to a legislative amendment that occurred in 2021. An explanation of the periodic updates for the federal NSPS, NESHAP, and MAC Federal Register final ruling notices and the need to update the through dates for Part 77, 78, and 82. An explanation of the vacated affirmative defense exclusion provisions that made up most of the Federal Register final rulings regarding how EPA approved state implementation plans for SIPs, treat excess emissions during startup, shutdown, or malfunction. New Mexico's SIP was interpreted to be substantially inadequate as published in the 2015 EPA SIP call and required for the removal of New Mexico's affirmative defense excluding provisions from the SIP to be in compliance with the Clean Air Act. The residual risk and technology reviews for industrial source categories of hazardous air pollutants is described where the Federal Register final rulings provides the subparts that contain the vacated affirmative defense provisions. The effects of incorporation are described with the history of the delegation of authority for the NSPS, NESHAP, and MAC standards, with the latest date of incorporation and the department's intent to maintain implementation and enforcement authority. The public outreach campaign for the proposed revisions is explained to meet the definition provided to the public. The Federal Register final ruling notice summaries for new or revised subparts are provided through NMED or Exhibit NMED 7, which includes 119 revisions and 2,438 pages of final ruling notice text if printed. The department has determined that the effect on small businesses will not have an adverse effect since the proposed amendments will not impose additional substantive requirements of facilities, but will simply allow the department to retain delegation of authority for implementation and enforcement rather than EPA.
Thank you, Mr. Paz. What is the purpose of the proposed amendments before the board today?
The purpose of the proposal was to incorporate by reference the federal rules for the NSPS, NESHAP, and MAC standards found in Title 40 of the Code of Federal Regulations, 40 CFR, Part 60, 61, and 63, respectively. Also, to update the statutory authority reference for Part 78 and 82 that was revised from the 2021 legislative amendment.
Can you please give a brief overview of each of the proposed amendments?
The department proposes to amend 3 rules in NMAC. 20.2.77 NMAC, New Source Performance Standards for Part 77, 20.2.78 NMAC, Emission Standards for Hazardous Air Pollutants for Part 78, and 20.2.82 NMAC, Maximum Achievable Control Technology Standards for source categories of hazardous air pollutants for Part 82. For Section 3 in Parts 78 and 82, due to the 2021 legislative amendment, the no longer applicable subsection C of Section 74-2-5 NMSA 1978 statutory authority reference must be correctly amended to subsection D of Section 74-2-5 NMSA 1978. Also for Section 3, Part 78, subsection A of Section 74-1-8 NMSA 1978 must be correctly reformatted to meet 1.24.11 NMAC. These proposed amendments are not part of the state implementation plan, but are federally enforceable under sections 111 and 112 of the Clean Air Act, as shown in exhibits NMED 4 through 6. Again, the purpose of the proposal is to incorporate by reference the federal rules for NSPS, NESHAP, and MAC found in 40 CFR Part 60, 61, and 63, respectively. To accomplish this, the due dates must change in the appropriate sections of each proposed part, indicating New Mexico request delegation from EPA to implement and enforce these federal rules. New Mexico has maintained delegation for the NSPS and NESHAP standards since March 15, 1985. And the MAC standards since July 27, 1995. Exhibits NMED 9 and 10. The department tracked the relevant Federal Register final rule notices for 40 CFR Part 60, 61, and 63 since the last amendment from January 16, 2017, and proposes to extend the due date to June 28, 2023. Exhibit NMED 7 provides a table summarizing the changes and the estimated number of facilities provided in Exhibit NMED 8. These amendments include 33 new or amended NSPSs, 2 new or amended NESHAPs, and 84 new or amended MACs. Several of these Federal Register final rulings have multiple parts, 60, 61, and 63, and are provided in full text through hyperlinks in Exhibit NMED 7, which are printed with total 2,438 pages. The reason for so many amendments was a result of the vacated affirmative defense exclusion provisions that was initiated June 30th, 2011 by a petition for rulemaking that was filed by the Sierra Club with the EPA administrator in regard to how EPA approved SIPs treat excess emissions during startup, shutdown, malfunction. New Mexico SIP was determined to be substantially inadequate based on the EPA's June 12, 2015 SIP call that prompted for the removal of the affirmative defense related provisions September 9, 2016 from the SIP and retained the original provisions that EPA approved September 14, 2009 as state-only regulations that are not fairly enforceable under Clean Air Act sections 110 and 113. Clean Air Act sections 110 or Clean Air Act section 110 refers to SIPs for the national primary and secondary ambient air quality standards. And Clean Air Act section 113 refers to federal enforcement. Affirmative defense means in the context of an enforcement proceeding, the response or defense put forward by a defendant regarding which the defendant has the burden of proof and the merits of which are independently and objectively evaluated in a judicial or administrative proceeding. More specifically, it is on state law provision in the SIP that specifies particular criteria or conditions that, if met, would purport to preclude a court from imposing monetary penalties or other forms of relief for violations of SIP requirements in accordance with Clean Air Act sections 113 and 304. Clean Air Act section 304 refers to citizen suits, and again, Clean Air Act section 113 refers to federal enforcement. The Clean Air Act requires EPA to regulate hazardous air pollutants from industrial facilities in 2 phases, either max every 8 years. The first phase is a relative risk based to determine whether standards have ample margin of safety and protect the adverse environmental effects based on improvements in air pollution controls or prevention. And the second phase is technology based and are based on emissions are achieved by the best controlled and lowest emission sources in the industry. Since the 2015 SIP call was issued, all the residual risk and technology reviews have vacated affirmative defense exclusion provision incorporated into the final rulings. Again, the reason for so many Federal Register final ruling provisions from past hearings since 2015 is because we have started reaching the 8-year relative risk and technology review period from when the Sierra Club successfully petitioned the EPA in 2011 to vacate the affirmative defense exclusions, which took effect in 2016.
Thank you. Can you briefly explain why the proposed amendments are needed?
For the department to retain the delegation of authority to implement and enforce the new and amended federal NSTS, NESHAP, and MAX standards through June 28, 2023 under parts 77, 78, and 82 respectively. The board is required to periodically amend the through dates for the federal standards under the Air Quality Control Act, subsection 4 of section 24-1-8 NMSA 1970.
Madam Hearing Officer, I'd like to ask a question if I could.
Go ahead,
Still
Mr.
on direct.
Yeah, go ahead, Mr. Cooper.
Thank you so much. I'm sitting here listening to this testimony, which is excellent. But I realize that we are deep in the weeds here. So for members of the public and for people who are not specialists, I just wanted to ask you a couple kind of, simple questions. Is this incorporation by reference, is this something that NED normally does?
Yes, they do it every 2 to 3 years.
They do it every 2 to 3 years. And in your view, what is the reason why? My understanding is, you look at the New Mexico rules and it'll say like, 20.2.77 A1, and it'll say incorporation by reference, and it'll cite to the federal rules. Why is that? Why do we cite, or why does NMED cite to the federal rules rather than just incorporate it, not by reference, but by text?
Well, because of the fact that we there's a certain number of actions every year, and so we have to keep up on those actions. Sometimes they vacate some of the previous actions, and so not only that, we also want to include the public as far as being able to have comments during our revisions or amendments.
Okay, and thank you. And one last question. If you were to give a guesstimate, how, when you were to print it out, say on an 8x10, sheet of paper, about how many pages would these amendments be?
About 2,438.
Okay, so is it your opinion that, at least in part, one of the reasons why we don't incorporate it would be that it would be redundant and maybe easier for members of the public to go directly to the federal site? Okay, thank you. I have no further questions. I'll turn it back over to Mr. Hirsch.
Mr. Paz, what would be the effect of the board approving the proposed amendments?
Incorporation by reference allows for the department to accept delegation of authority to implement and enforce the federal NSPS, NESHAP, and MAC final rulings. Although EPA still retains the primary authority to enforce the standards. Interact sections 111, 112 authorize the department to accept delegation authority as provided in Exhibit NMED 14. EPA initially granted delegation of authority to the department on March 15, 1985 to implement and enforce the NSPS and NESHAP standards as provided in a letter to the governor in Exhibit NMED 9. In addition, EPA initially granted delegation of authority to the department on July 27, 1995 to implement and enforce the MAC standards as provided in Exhibit NMED 10. The delegations of authority are currently in effect, and by amending the 3 dates, the rules signal to EPA and the regulating community that New Mexico has requested delegation of the specified federal NSPS, NESHAP, and MAC rules. The latest date of EPA approval of the department's requested date changes for all 3 rules was April 13, 2018. Delegation of authority to the department is more efficient and effective than relying on federal implementation and enforcement, as the department is in a better position to determine which standards are applicable to sources by writing permit conditions and determining compliance through inspections along with the necessary enforcement action. But the EPA and the regulated community generally prefer that the department implement and enforce these federal air quality rules based on efficiency and best use of resources.
How would the proposed amendments affect small businesses?
Pursuant to the Small Business Regulatory Relief Act, the department has determined that the proposed regulatory changes will not adversely affect small businesses. The proposed amendments do not impose additional requirements of facilities. They simply allow the state to implement and enforce the federal rules instead of EPA. Additionally, the Department's Small Business Environmental Assistance Program provides ongoing technical assistance for small businesses regarding new and existing environmental regulatory requirements.
And what was your role in developing the proposed amendments?
As a lead analyst, I drafted and implemented the limited English proficiency, or LEP, as part of the SIT protocol as used for rulemaking activities, compiled and analyzed the Federal Register final ruling notices, and created a matrix to tabulate the summaries based on the dates from oldest to newest, and whether the action was a vacated affirmative defense exclusion revision, a correction, whether it was a new or amended rule, the total number of pages in the document, and a hyperlink to the full text document. Compiled a list of the number of facilities by subpart that may be potentially affected by the amendments. Drafted the format of the proposed amendments and had our state record center and archive analysts review the draft revisions. Coordinate with EPA on how to properly proceed with proposed amendments to obtain approval. Executed the public outreach campaign that includes posting the public notices in English and Spanish on the department website, Sunshine Portal, sending out to the department listserv, New Mexico Register, Public Journal, and to all the various stakeholders as listed in the limited English proficiency plan, by meeting the definition of providing to the public.
Did the Air Quality Bureau receive any public comments on the proposed amendments?
No comments were received during the open comment period.
Can you describe the Bureau's efforts with regard to public outreach?
Initial outreach began on September 12, 2023, with a notice in English and Spanish to the Bureau's regulatory listserv announcing the proposed incorporation by reference of federal NSPS, NESHAP, and MAC amendments. Exhibit NME 12. Notice of the proposed amendments was also published on the department's public notice website at the time. Public notice was published in the Outer Journal in English and Spanish and the New Mexico Register on September 12, 2023. Exhibit NME 11. The public notice included an option to request an informational open house. However, no requests were received. The public notice was provided to the 25 tribes, pueblos, and nations, 23 land grants, and the Council of Governments, which represent the colonias throughout the state. The department also complied with the Small Business Regulatory Relief Act. A letter was emailed to the Small Business Regulatory Advisory Committee on September 12, 2023, Exhibit NME 13. No comments were received from the Small Business Regulatory Advisory Committee. The public notice was posted on the Sunshine Portal on September 12, 2023, along with an email sent to the Legislative Council Service with the public notice attached as provided in Exhibit NMED 16. The public notices were posted in English and Spanish at the department's local field offices throughout the state, as requested by the Environmental Health Bureau Chief as provided in Exhibit NMED 17. Additionally, the proposed rule amendment have been posted to the department's proposed air quality regulations and plans with it.
Thank you.
What steps did the Bureau take to facilitate public and stakeholder input in the proposed amendments?
The first introduction to proposed incorporation by reference amendments to the public involved a series of 3 public web-based evening stakeholder engagement meetings from 4 p.m. to 6 p.m. on February 23rd, 2023, March 30th, 2023, and April 27th, 2023. The meetings were to inform the public of upcoming rulemaking and state revision developments. The public involvement, or the limited English proficiency plan, list of timeline of events to meet their statutory requirements and meet the definition of providing to the public to facilitate community engagement for input and feedback in a timely manner to address the comments into the final amendments. The public outreach efforts that began on September 12, 2023, with providing the public notices in English and Spanish to the general public and targeted stakeholders was the effort the department provided the opportunity for public comment. My contact information was provided with the public notices. Reached out to me to provide comments or concerns. A public comment portal posting was open on the department website from September 12, 2023 to October 12, 2023. No public comments received.
What is the department's policy 07-11?
Policy and procedure 07-11 is the department's limited English proficiency, or LEP, accessibility and outreach policy.
Did the Bureau follow this policy in preparing for this public hearing?
Yes.
Can you describe how the Bureau gave formal notice of today's public hearing as required by regulation?
Drafting the notice of hearing for requirements in 20.1.1 and 9. The notice of hearing was translated into Spanish by Ana Maria McDonald, the translation program manager for NMED. No comments were received during the open comment period. The notices of hearing in English and Spanish to the Office of Public Facilitation, and they posted the notices in English and Spanish on the department's document matters website under the Environmental Improvement Board drop-down. In the section for EIB 23-52R, and the matter of proposed amendments to 20.2-77 NMAC, New Source Performance Standards, NSPS, 20.2.78 NMAC, Emission Standards for Hazardous Air Pollutants, NESHAP, and 20.2.82 NMAC, Maximum Achievable Control Technology for Source Categories of Hazardous Air Pollutants, MAC. The Bureau posted the notices of hearing in English and Spanish on the department's public notices website under the statewide dropdown in the section for public meeting notice. The Mexico Environmental Improvement Board notice of rulemaking hearing. The post included text about the public comment and technical testimony requirements to the EIB in the public hearing scheduled on November 17, 2023, NMED Exhibit 12. Additionally, the public notices were posted in the proposed air quality regulations and plans webpage. The notice of hearing was published in English and Spanish in the New Mexico Register and Albuquerque Journal on September 12, 2023, Exhibit NMED 11. On September 12, 2023, emails through listserv were sent out with the notice of hearing in English and Spanish attached. The email messages announced the date for the public hearing before the EIB, Exhibit NMED 12. Emails with the attached notices in English and Spanish went to the Council of Governments, 23 land grants, and the 25 tribes, pueblos, and nations throughout the state that are provided on the department's internet contact listings. As stated earlier, Exhibit NMED 16 provides the screenshot of the Sunshine Pearl posting on September 12, 2023, and the email sent to the Legislative Council Service. And Exhibit NMED 17 provides the email to the Environmental Health Bureau Chief requesting for the public notices in English and Spanish to be posted at the NMED field office throughout the state.
What is the Bureau's recommendation regarding the proposed amendments?
The Bureau recommends that the board approve the adoption of the proposed amendments.
Thank you, Mr. Paz. I have no further questions. Mr. Paz is now available for cross-examination.
Thank you, Mr. Paz. Does the board have questions of or wish to cross-examine Mr. Paz? Mr. Bitson, Member Bitson.
So, Mr. Paz, you were grilled by counsel here earlier about why you do things by reference rather than publishing the text. And part of your answer, if I recall, was that you said there were about 2,438 cases. Sounds more like a very specific number than an about. I mean, you nailed it, right? 2,438. So I don't know why you threw about it. I was carrying once in a while, high and low. Always 2,438.
No, it's all depending on the, I guess you could say, number of final ruling actions and how many pages are included in this.
And then at the end, you said 25 tribes, Pueblos Nation. Does that include the Chiricahua Apache, who I think have federal recognition now in the state? I'm not sure if they have state recognition. I'm not sure, I'm not up to date on that, but I remember they were petitioning for it.
But Chihene Indian?
Chiricahua?
No, I know the Chihene Indian were petitioning, but.
No,
Oh,
this would be, they were Fort Sill,
Yes.
1887, captured as an army in the field. Men, women, and children moved to Florida. Didn't do well there. Folks felt bad about how fast they were dying off. They got moved to Georgia, didn't do much better there. Moved back as close as the U.S. Army could let them come at the time. Yeah, from their perspective, and that was Fort Sill, Oklahoma. Ever since then, they've been trying to get back to New Mexico. I know they achieved federal recognition. They have 30 acres of Aquila Flats off of I-10. That's their sort of residual homeland, but I don't know if they are part of the 25 entity notice sovereign. I know recognized federal, but I don't know if the state of it.
I think I do remember seeing their name on that list. I do, because they are, I think, they're in Boone County, which is close to
That's
them.
not right. Yes,
Yeah.
very close. Houses, is a tribal chairman. The artist Hauser, you know, the sculpture out front of the Capitol, the sculpture of the guy shooting around in the sky, graces the Oklahoma license plate. That's the tribal. That's his father, the artist. Very cool. Little bit of trivia. I've lost touch with them, so I didn't know. But if they were now, sounds like we're in a state recognized as well, and after recognizable as the best. I don't know. Anyway, I'm glad to get it.
Any other board questions?
No questions, thank you.
I have one question. Mr. Paz, you testified to this. I didn't quite get it. It's still not, it's not clear to me how the change in the affirmative defense is actually connected with these proposed amendments. Could you quickly summarize that? Thank you.
Yeah, so it's pretty much anything that has any of the elements as far as alternative emissions limitations or emissions limitations, anything having to do with monitoring, record keeping, or even submittal of reports.
So is it that because the affirmative defense has been rejected by the courts and EPA, that you had to actually take it out of these federal rules? Or you didn't, the feds took it out, and so
That's correct. We
that's
have
the
to-
connection.
Yes, and we had to take it out of our SIP. And so that's what we had, that was action that we had to take to be able to be in compliance with the Clean Air Act.
Great, thank you.
And can you, if I may, Madam Hearing Officer?
Yes.
Can you just share with us the acronym of SIP?
State Implementation Plan.
All right. Just making sure. Get that on.
Does Mr. Maxwell, do you wish to cross-examine this witness?
I have a few questions.
Please go ahead.
Are there any foreseeable challenges, such as long-term drought or risks, in enforcing these proposed amendments?
No.
Have there been any aspects of the proposed amendments that sparked significant debate or controversy?
No.
You mentioned that there were no comments during the review process. How do you interpret this absence of feedback?
I feel like it's an indicator of how well the federal comment period was initiated, because each one of these final rulings allows for a public comment period. So I feel like industry was able to adequately address their comments during that time.
Thank you. I have no further questions.
Thank you, Mr. Maxwell. Does anyone else, including the audience, wish to cross-examine this witness?
I just have one follow-up, Madam Hearing Officer.
Yes, Madam Chair, please go ahead.
And I apologize, I should have, I'm still waking up on my coffee here. Long week. So can you, explain, I know you had a comment about, effect on small business and, the outreach that you did, maybe a little bit of a follow-up to Mr. Maxwell's comment. Did you get any response back from the Small Business Regulatory Advisory Commission?
No response back.
No response back. Is there any other review or analysis you did in relation to any effect on small business? Is there like, the local small business administration office or any other outreach that you or the department has done?
Not that what we already do with our small business assistance program.
All right, but to Mr. Maxwell's point is, do you foresee any issue with an effect on small business based upon what you do, what you've looked at in terms of the amendment to this rule?
No, reason being because it's not being more substantial requirements. They're already in place. It's just that we're just getting the delegation of authority from the people.
Okay, thank you.
That is all the questions for this witness. Do you have any redirect or anything?
No, we don't have redirect. We have Kirby Olson, who's available for larger programmatic questions if members of the board have larger programmatic questions, but Ms. Olson doesn't have any direct examination or direct testimony.
Okay. Great. So your case is the rest. Okay, great. So we will now hear from Mr. Nicholas R. Maxwell. Mr. Maxwell, do you wish to make an opening statement?
I have no opening statement. Thank you.
Okay. We will now then move on to non-technical testimony and take statements from members of the public. Any testimony must be limited to the proposed amendments. The board is unable to take any testimony unrelated to these amendments. Will the administrator unmute members of the public one by one and ask if they would like to present non-technical testimony? I think it'd be easier for members of the public to raise their hand, and Pam could, the administrator, Pam, can unmute you if you have a non-technical testimony. Right, it doesn't look like there is anybody on the platform who wishes to make a statement or provide non-technical testimony, so we can move on. Okay. Okay, any person who testified and who wishes to make a brief closing argument may now do so in the same order of the direct testimony. We will start with the petitioner.
No closing statement. Thank you.
All right, be ready to close the hearing? Mr. Maxwell, would you like to make a closing statement?
I have no closing statement.
Okay. Yes. Okay, so I'd like to thank the board and everyone present for their participation today. A quorum of the board members were in attendance. The hearing notice indicated that a decision might be made at the conclusion of the hearing. The board may immediately deliberate and decide on the proposed regulatory changes at the conclusion of this hearing. The record of this public hearing is now closed. Let the record show that the hearing was adjourned at 10:03 a.m. on November 17th, 2023.
Thank you so much, Madam Hearing Officer. And again, we are still on this agenda item number 5, which is now that the public hearing has been closed for EIB 23-52R. Here, so the board, we can elect to deliberate immediately and just looking at the board members, and if you would like to deliberate immediately, Member Bitzer. I'm seeing nods and thumbs up by Vice Chair Trujillo. Yes, okay, looks like the board will immediately deliberate to make a decision on the proposed amendments that the department has proposed. And I guess, yeah, and so why don't we start deliberating and discussing the proposed amendments by NMED? And I look to fellow board members as to maybe an opening of discussion. Yes, Member Honker.
Well, it sounds to me like it's pretty straightforward. This is for consistency with the federal program. It sounds like NMED did a good job of public outreach. And basically there's no technical comments with the proposed rules. So that's what I'm hearing.
Thank you. Yes, Member Garcia.
Thank you, Member Honker. I was going to say the same thing. I would only add that I understand that keeping the New Mexico regulations in conformance with the federal regulations is a requirement for a delegated state. So they have to routinely make changes in accordance with whatever federal changes have been made. And so I think in order to be consistent with federal regulation, it would be appropriate to incorporate these amendments into the New Mexico regulations.
Thank you, Member Garcia. Yes, Member Bitzer.
Nothing personal about Mr. Honker, but I'd rather have the state doing the regulating than the federal government doing the regulating. Sounds to me like that's the alternative if we don't do this, so.
Thank you, Member Bitzer, for that comment. And just checking the platform here for Vice Chair Trujillo.
She's got her hand.
Yes.
Yes, I thought I should get my comments on record. So I agree with Member Honker's sentiments as far as the bringing up to the federal standard, and that NMED did a good job in noticing it. Actually, I remember hearing about this a long time ago, so I just concur with his comments on it.
Thank you, Vice Chair Trujillo. And any other board members have any comments? And to your comments and the comments of the my fellow board members, seems to be that this is pretty straightforward. Reviewed the submittals by the department. And thank you very much for that crosswalk table. I know that took a long time to do as part of what you all developed for us, but it does really help and helps document the changes. So I appreciate that, and for clarity and transparency. So thank you, Mr. Claus, for doing that. And I support that. Seems pretty straightforward. So with that, just looking around, it seems like we are moving toward a decision, and just looking around if anybody wants to make a motion. Yes.
I'd be happy to try to make a motion.
Just use the language, or I can pull it up here right now. What's that? Language for the motion?
Yes. All right.
Can you read that?
Oh, okay. Member Ely?
Yeah, I move to adopt the proposed amendments to 20.2.77 NMAC New Source Performance Standards, NSPS, 20.2.78 NMAC emissions standards for hazardous air pollutants, NESHAP, and 20.2.82 maximum achievable control technology for source categories of hazardous air pollutants, MACT, based on the evidence and the testimony presented by the petitioner.
Thank you, Member Ely.
I'll second.
Thank you, Member Hunker. And just double checking with our board members, see if there's any further discussion, comments, revisions to the proposal, motion, the proposed motion. If not, Ms. Jones, would you please do a roll call vote on Member Ely's, motion?
Yes. Member Bitzer, how do you vote?
I vote yes.
And Member Ely?
Yes?
Member Honker?
Yes.
Member Garcia?
Yes.
Member Trujillo?
Yes.
Thank you. Chair Sweeney?
Yes.
The motion passes.
Thank you, Ms. Jones, for that, and I appreciate, again, you being the hearing officer, Member Ely, that helps us, facilitate and move through some of these, tasks and items. And thank you to the department, Mr. Vigil and Mr. Paz, and of course, and congratulations on making it through at least to this point on with your, legal education, and thank you for participating as well. Ms. Olson as well.
Chair, did you see the email I sent you?
Yes, yes,
Yeah.
okay,
Madam Chair, I have a question if that's okay with everyone.
okay.
What would be most helpful for board counsel and the hearing officer with regard to an order, findings of fact and conclusions of law? I don't want to make more work for anyone, but I'm just curious what would be most helpful in terms of, producing those documents. Do you need any help? Is there anything I can do?
I was gonna go ahead and draft a statement of reasons and I can provide it to you for review to ensure that it comports with what you guys presented, and then we can have the chair sign it.
Okay, great.
Yeah, that was my intent, but let me know if you want to do something different.
Thank you for bringing that up, Mr. Vigil, and appreciate that, legal counsel Bowen. So with that, the board's decision will be issued in writing, and will include its reasons for the actions taken today. The board administrator shall provide the notice of the board's action to each of the participants in the hearing and to all other persons who have made a written request to the board for notification of action taken. And so we'll work with the department and making sure, whatever is easiest, and I'll look for that notice from you.
Absolutely.
As well, Ms. Bowen. With that, so, thank you again.
Thank you.
For being here today, and again, apologize, still trying to get going. Keep going. All right, so with that, thank you, and it looks like agenda item number 5 has been, and you're welcome to stay. I know our meetings are very exciting.
And there's food.
And there's food, please, there's some bagels. And thank you, Mr. Maxwell, I forgot to mention that, appreciate you attending, and, I know you as well have had a long week, and, appreciate your participation. And just thank you so much for your engagement and your interest in this week's activities and meetings, appreciate that.
Thank you.
All right, so next item on our agenda is item number 6, which is next meeting and upcoming matters. And Ms. Jones, I know we're looking at
Yes, we have our December meeting, and I think we had agreed at some past meeting that although it is ordinarily scheduled on the 4th Friday, which is the 22nd of December, we're going to the meeting on the 15th.
right, yes.
And there is an item that for hearing, and that's EIB 2359, and that's amendments again to some radiation regulations. council is Lisa Chai and Tatiana Engelman. And I believe that they're asking for a continuance.
Oh, they are, okay. Before we do that, I forgot about our court reporter. And thank you so much for being here. I didn't mean to miss you.
Thank you, right?
Yeah, thank you for your service and for coming here this morning for our
Thank you so
hearing.
much.
Appreciate that. I'm sorry.
No,
Yeah,
that's
I
okay.
just wanted to-
That would be the only item that's on the agenda at this point.
Okay,
So,
so they're asking for a continuance.
A motion has been filed. And that would be your only agenda item. They're asking for it to be continued until your regularly scheduled meeting in February.
Oh, okay.
Okay.
Is that on our docket already?
yes.
Okay.
And there's no meeting in January because of the session.
That's my understanding.
Yes, yes. And looking at board members, I know,
Well, what date of February do we have?
yes.
It's a good question.
Let's, can you pull up a calendar?
Yeah.
I don't have.
Yes.
February 23rd.
23rd.
February 23rd is the,
Yes.
Excuse me. I don't know if you guys can hear me okay. I
Yes,
asked
yes,
if I could be removed as hearing officer for that hearing, the February one. I did hear that member Honker was volunteering to take that spot for me. But I'm just kidding, member Honker. I just give you a hard time because you weren't there to defend yourself yesterday. But yes, I did actually ask to be removed from that particular hearing, and I'd be happy to take the next one coming up. So if we could maybe designate another hearing officer for that, that might be a good point of business right now.
Thank you, Vice Chair Trujillo, for chiming in on that and bringing that to our attention. And I think we all took a vote yesterday, remember?
At around 10 p.m.
And I'd be happy to do it. My only concern is, and I know my travel schedule seems to be unreasonable, but I'm scheduled to get back from a trip, an overseas trip, the day before that. So assuming my flights are on time, I'll be happy to do it. But
That makes it a little bit.
Yeah.
I would point out also that I think your term and my term have expired. So in theory, are you reappointed
no, I'm still in my original
in limbo?
3 years.
Okay, but you're not out. I mean, you'd be fine in that regard. I was thinking there should be somebody whose term isn't expired in case there's a replacement appointment, but.
Yeah. So what was your travel considerations?
I'm getting back the day before on the 22nd. Let me just check mine.
Okay.
Flight schedule.
I don't even want to, no worries.
Bali.
Who else has, someone else on the board has an expired term besides me?
I think it's, yeah.
It's,
Vice Chair Trujillo.
Trujillo.
I'm supposed to get it back at
Yes,
2.
it's me.
Thank you, Vice Chair Trujillo.
I should be back
You should be
around
back.
2 o'clock the day before, so there's some cushion there.
Okay.
And I'll certainly be happy to do it.
Okay.
If you feel like you won't have time to prepare, I can step in. Cause I know how that feels when you're coming back from overseas, you're kind of, it takes a little while to put your feet on the ground. So
Yeah,
if you like, I'll be happy to take that and then you can take the next one.
okay, all right. I should take the next 2 or 3. So I appreciate that.
Okay, so member
Member
Garcia,
Garcia, so
perfect.
do we need to make a motion? Because I think we made a motion to identify Vice Chair Trujillo.
Yeah, you can. Technically, you can just do it by order, but if it feels cleaner to you. And then I'll go ahead and draft an order to clarify me if I'm wrong, grant the continuance and appoint member Garcia.
Yes, so just again for points of clarity. So should we make a motion to grant a continuance just for the record?
If you want, yeah.
Okay. Yes, Member Humphrey.
So I will move that we grant the requested continuance on EIB 2359. And reschedule that hearing for our regularly scheduled meeting on February 23rd, 2024. And that instead of Vice Chair Trujillo, the very gracious Member Garcia will serve as hearing officer for that year.
Second that.
Thank you, Member Honker, Member Bitzer for your second, and Member Honker's motion. With that, can we just, Ms.
Sure.
Jones do a roll call vote?
You bet. Member Bitzer, your vote?
Yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
Chair Sweeney?
Yes,
The motion passes.
thank you so much. So with that, Ms. Jones, for the December meeting, right?
Correct. At this point, then, we wouldn't have any agenda items up to this point, but
Okay,
Yeah.
but we'll wait
Yeah.
to see if, anything comes to the board.
that's right.
Okay,
That's right.
okay, so just putting that on everybody's schedule still, even though we're moving the hearing, let's keep that, that date marked in case we get, agenda items between now and then. Is that okay with everybody?
Yep.
Yes. Yes,
And,
member,
and we will not be holding a meeting in January? Is that?
yes, no,
Okay.
yeah. That's, yeah, our plan at this point, on November 17th is not to have a meeting.
Time to travel.
December we're freed up to then.
No, we're
Yeah.
gonna,
Not yet.
maybe
Keep it on the
Tentatively.
calendar.
tentatively, but we're gonna hold, December
15th.
15th. We'll still hold it, in case we have agenda items that come. So we're not off the hook yet, not quite. And, so with that, if there's no other discussion about upcoming matters or our next meeting, we'll go on to agenda item number 7, which is adjournment.
I will move, we adjourn.
Second.
All right, with that quick roll call vote, Ms. Jones?
That was Member Honker and Member Garcia?
Correct.
That was quick. Member Bitzer, your vote?
Yes.
Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Vice Chair Trujillo?
Yes.
Chair Sweeney?
Yes.
Motion passes and we're adjourned.
Thank you, Ms. Jones.
Just so you guys know, you don't have to do a vote for adjournment. I know you like to, so you're welcome to, but if you don't legally have to.
Okay, thank you.
It is a fun night.
Thank you.
Yeah, it's like the most fun vote that we get to do.
Wasn't you for December AGEI hearing? No?
Oh.
Is that not